Hey, sorry everyone for the delay there. So Axel's running a little bit late, but I have Laurie here and luckily she can wear both hats. So she can answer both the questions for us in the meantime till Axel joins us. So the format of today, the reason why we at SAMPS decided that this would be a great session, we ran another webinar on CRMs in general and all of the questions we got afterwards were about compliance and GDPR and CCPA. So we thought it would be great to delve into that more deeply. So we have Laurie here, who is our CCPA and GDPR expert, and Axel's based in Sweden, and he's focused on GDPR as well. So hopefully he'll be able to pop in and answer more on our GDPR side. But in the meantime, hi Laurie, thanks for joining us.
Hi Laura, thanks for having me.
So the format of today, what we're going to do is just have a chat. We can answer any questions that come from the audience. We have a few questions that we wanted to run through that I was sent via LinkedIn and through the SAMPS website. And then we have sessions afterwards. So we'll break up into meeting rooms. So yourself and yourself will have a room. Axel will have a room. People can come in and chat to you one-on-one in a more interactive way.
Mm-hmm.
And we also have sort of speed networking. So that's like your speed dating idea as well. So that'll be running at the same time and afterwards where people are matched sort of randomly. And it's just a nice networking given that we can't really meet face-to-face these days.
Okay.
So just even to get us kick-started then, I mean, in terms of we're here to talk about CCPA and GDPR. So, I mean, what are the differences between the two and should we focus on one or be looking at both separately?
Good question. There is some overlap. So just for background, the GDPR was enacted and came into effect in 2018 and the CCPA in 2020. There are some similarities between the two. Data subjects or individuals have the right to make certain requests regarding their personal data, request to access a copy of their data, request to delete their data. There are certain types of requests you're allowed to ask for under GDPR that aren't really under CCPA, but for the most part, it's quite similar. There are also some transparency requirements around what you have to include in your website privacy policy. Those are fairly similar, I would say, from across the two laws. You're supposed to also have contracts with your third-party data processors to make sure that you're ensuring that they're in compliance with data protection laws as well. And lastly, kind of the last overlap item would be privacy notices for your employees. Those are required under both the GDPR and CCPA. You're required to notify employees what data you're collecting and how you're using it.
Sorry, so a lot of the guys that will be watching will be thinking from their perspective of their customer, so who's in their CRM, what they can and cannot do.
Mm-hmm.
So today, I mean, my understanding was GDPR was maybe a little bit stricter than CCPA, so if you were going to, put a policy in place really to make sure that you are compliant with GDPR, will you automatically tick the CCPA box?
No, unfortunately. Okay. The principles behind the laws are similar, but the way they went about sort of compliance was kind of a lot different. So under GDPR, you have to have a legal basis for data processing. That's not required under the CCPA. In some cases, you're required to have a data protection officer under GDPR if you're processing data not under CCPA. Things like that. Under CCPA, also has some unique requirements. There's a requirement that you have a notice of collection where you're collecting data. So notifying users what data you're collecting and how you're going to use it. For data subject requests, you're required to allow people to call. You're supposed to have a toll-free phone number. And you're under the CCPA, you're not required to have people opt in to marketing like you are under GDPR. There is an opt-in requirement in most European countries under GDPR. So that's a big difference between the two. And under CCPA, you're required to give people the right to opt out of the sale of their personal information. That right doesn't exist in GDPR.
And in terms of the opt-in in GDPR then, so people are asking, how do I get people to opt in if I'm not allowed to message them in the first place?
Good question. I think you just put opt-in boxes everywhere you can.
Yeah.
On your website, on every page, wherever you're collecting data, put that opt-in box there. Make it as prominent as possible, and I don't know, put it in some bright and cheerful color.
Yeah. And in terms of, from a CCPI point of view, if you were to, for example, then find, so a lot of us would sell into the academic world. So, for example, they would have an academic web page and their email address would be sitting there in association with their research. So in terms of that email, because that's publicly available, how does that affect the law?
In the U.S., you're allowed to use it because it's an opt-out regime in the U.S. So you can email someone until they tell you not to. In Europe, you're supposed to have an opt-in. So technically, you're not supposed to use data like that where you don't have an opt-in consent.
And in terms of, a lot of clients or some clients deleted their entire CRM, those that took the GDPR very, very seriously. Was that required, or was that did that need to be done?
Not necessarily. It depends on kind of how you got your data to begin with and whether you have an argument or had an argument at the time that you had some kind of consent, some kind of implied consent, for example, somebody, some indication somebody wanted to work with you. So I think people who had a lot of data in their systems where they couldn't document anything and were taking a conservative approach, got rid of their CRMs, but it wasn't necessarily in every case, and it was, should have been kind of a case-by-case analysis based on where you got that data.
So this is a bit like the legitimate interest clause within the GDPR, where, if you can legitimately argue that the person will be interested in what you're sending them, then then you're okay to do so. The problem is if you don't know where you got the data from in the first place, how can you stand up and argue that they would be legitimately interested if you don't have that sort of background?
Correct. Yep.
Understand. So if you're going to have these people in the CRM, you need to have that sort of background information in our context, maybe their research, so that you can, if it comes to it, say, look, I messaged you because you have a grant in stem cell research, so I thought this webinar might be relevant to you.
Yeah, and in Europe, I think detail like that would be helpful.
Perfect. We had a wee poll actually that was really determining who's doing what type of marketing, which would be interesting to know. So who's sending one-to-one, who's sending one-to-many. I think my colleague will put that up and people can vote. There it is up now. So it's just here on the right-hand side under polls. Because really the big question for everyone is, can I send these mass emails? If I can argue legitimate interest, if my CRM is nice and clean and I have all of the applications there, am I okay to send a mass email, or do I need to sort of send that one-to-one even if I have that sort of legitimate interest ticked?
If you're really sure about the quality of your data, you can send mass emails. Just be aware that, penalties can be assessed on an email by email basis, so you do want to just make sure, doubly sure that you're compliant. In the U.S., commercial email is actually governed by a law called the CAN-SPAM Act. So you need to make sure that for every email you send in the U.S. that they comply with the CAN-SPAM Act requirements, which include things like an unsubscribe mechanism and, accurate subject and header information, a postal address, just some basic requirements for that. So as long as you're sure that your data is good and that you carefully comply with, those types of requirements, then you should be good.
I mean, in a way, it just forces us to be better marketers in a way. The fact that we now need to target it to the right audience to make sure that they would be interested. It's just really what we should be doing in the first place to get a better return.
Yeah, I think a lot of people found that even though they dropped a lot of people, unsubscribing around the time GDPR came into play, the quality of their data became better because it was more based on people that actually want to hear from you.
Yeah, perfect. And in terms of the sort of fines, what's the process? So like, would you just have someone knock on your door and say, here's a fine for $1 million? Or do you get, a warning letter so that you can maybe change your processes if they weren't ideal?
I'm not 100% sure what what the process is in Europe. In the U.S., under CCPA, for example, you would essentially get a notice, a warning letter from the California Attorney General's office, and they would give you 30 days to cure your violation. If in 30 days they've decided that you haven't yet complied, then they can file a lawsuit in the California courts. And individuals can file lawsuits as well in the U.S. And those, you wouldn't get notice of that in advance. You would just get that when they're filed.
Okay, interesting. So we'll catch up with Axel and find out for GDPR, maybe put that in the blog that we'll post after this, just for the answer to that in terms of Europe. And I mean, in terms of the people being fined for this, my understanding was, certainly for GDPR, is it was created really for, the banks and the Googles and the Facebooks, and, now my hairdresser is making me sign a piece of paper to say that they can hold my data. And I just, would you say that was sort of not what the law was intended to be, or who's actually being prosecuted for this?
I mean, the big prosecutions and the big money fines are going to the companies you would expect. The Googles and the Facebooks of the world, the Marriotts that have the huge data breach, companies like that. But there are a lot of cases involving smaller companies, retail outlets. It just runs the gamut. So it's not necessarily targeted at just the big guys.
It looks like we have lost Laura.
I think so. Can you hear me?
I can hear you.
Okay.
Hopefully we can continue. What else can you tell us, Lori, about where we were going with that last train of thought there, while we wait for Laura to come back in?
I think it was talking about, enforcement. Yeah. So I think it was about done, but basically discussing fines and penalties and who the targets are. They are the big companies, but there's also a lot of smaller companies and in all kinds of industries. And that's what we're seeing in the California litigation as well. There's big companies and smaller outfits.
We had a question from one of the attendees, and he wanted to know, how often do you have to change your opt-in details, or how often do you have to update those kinds of things?
I'm not sure what he means by opt-in details.
The question was, how often do you need to update opt-in to make sure you are compliant?
I see what they're saying. People opting in. I would say every couple of years, probably every 2 to 3 years, you want to scrub your data and make sure you have opt-in consent for the people that are on your list.
Good. All right.
I can talk about pending legislation and new laws in some of the U.S. states and some other countries, if that's of interest.
Yeah, it'd be great.
Okay. So we had the CCPA come into effect in 2020, and back in November of 2020, California actually enacted a ballot initiative to add some new requirements to the CCPA. This is a new law called the California Privacy Rights Act, or CPRA. And the CPRA adds a couple of new rights for data subjects, one of which is requesting correction of their data in your systems. It also eliminates some of the exemptions that are in the law currently for employee data, and also some business-to-business data is exempted right now, the transactional business-to-business data, not all business-to-business data, but some. That exemption will be going away. And in addition to the right to opt out of the sale of your personal information, data subjects will be allowed to opt out of the sharing of their personal information for behavioral advertising purposes, which is probably the biggest potential coming change in California that would be of interest. And then there's 30 other U.S. states that are looking to copy California laws. That are those pieces of legislation are kind of in various stages. The ones most likely to come to fruition soon are in Washington State, New York State, and Virginia. In addition to that, Brazil passed a GDPR-like law back in the fall. They're in the process of implementing that. And Canada has introduced new legislation that's going to bring their law to be much more to the level of GDPR. So that's coming at some point. And also China is in the process of kind of slowly making more restrictive requirements for Chinese personal data.
Basically, I was asking, are there some good websites or some places that you could refer some people to go to that they might want to follow up afterwards?
Sure. So the California Attorney General's website has some really good information about the CCPA and the coming CPRA. And in terms of GDPR, the Information Commissioner's Office in the UK has a really good site that has a lot of information and templates and helpful guidance that I would recommend from the GDPR perspective. And I can get you links, Laura, if you'd like.
That would be great. Sorry about that, guys. I don't know what happened. I blame the Irish internet system. The other thing that Axel and yourself we were talking about before this call was the EPrivacy legislation that's coming in Europe in the future. So what Axel was explaining to us was while GDPR sort of captured everything and we kind of got caught up in the mix in terms as marketers, the EPrivacy legislation will be much more clear for us. So it will be, you can message this person in this country, you can ring this person in it. So right now that actually doesn't exist, but it will come. I was asking him in terms of dates and he said it had all been delayed in terms of COVID and there isn't even a set date. So I don't think it's in the near future.
No. It's been delayed for so long. It was supposed to come online in 2018 with GDPR and it just has been delayed and delayed. It's so controversial too, which is part of the reason why we're seeing this delay, and it's not forthcoming, I don't think, anytime soon.
And that's is why, like, there's a lot of confusion, particularly around GDPR, because it doesn't, a lot of companies are interpreting it in different ways. Some are being really hardcore because they're not really sure. Some are being sort of carrying on as normal. And the reason for that is this other legislation was meant to come in place and make it a lot clearer. So we're sort of, that's why this conversation was really useful to sort of work out what we can and cannot do.
Yeah, I mean, to some extent, we're taking some guesses, right, and trying to just be reasonable about what we do to comply with some basic GDPR requirements without the guidance, the detailed guidance that we need.
So it sounds to me, just to sort of summarize so we can break out into our networking session, I say we're coming up in the half hour, that in terms of GDPR and CCPA, you need to have your due diligence, like your unsubscribe button, all of that is a given. You need to look at the quality of your data because you need to be able to message people that you think will find what you're messaging relevant, so that's your legitimate interest. And if you are confident that your data is nice and you can refer back to their research in our case on why you can message them, then we're good to mass mail as GDPR and CCPA are for at the moment.
Yeah, under GDPR, you just need to make sure you have evidence of some consent.
Before we move on, we have a few questions. I'll ask them and you guys can answer. Jennifer's asking, can you talk more specifically about using data to track people while you're on your website?
Like cookies and things like that. In those cases, you should have a cookie policy posted on your website that describes what tracking technologies you use, what data is collected, and what that data is used for. There are cookie rules in the EU that require you to have a cookie banner on your website that requires people to basically, in Europe, to accept cookies before you set them. That requirement doesn't exist elsewhere. It's an EU-specific requirement. But if you're doing business in the EU, most companies opt to have that banner to comply with EU law.
Recently, I personally noticed there's been some changes to those. Before it was, do you accept cookies or not? Now you're getting some choices. You can opt into certain kinds of cookies and things like that. So you can really control your own data now.
Yeah, that's correct. And companies prefer it because it really gives people a choice. And some people are willing to accept certain types of cookies to get certain functionality on a website.
Good. We have one more question. It says, companies in Asia, often China in particular, are known for spamming. I'm assuming that jurisdiction in both laws is focused on where enforcement may be in practice, i.e. email senders located in the EU or in the US. Are there any impacts on either law as in terms of deterring companies based outside of these regions from less savory practices?
So I guess there is, what if my competitor, I'm based in the EU, my competitor is based in China, from GDPR, does that mean they can do whatever they want, but I can't?
I mean, if they're doing business in the EU, they're subject to EU law, they're subject to the GDPR based on the terms of the GDPR. Whether they could be enforced against is another question. And they're probably taking a gamble that they wouldn't be enforced against or it wouldn't be possible, which is why you probably see those disparities. There's not a lot you can do about it other than reporting someone who's not complying with the law that applies to what they're doing.
Although it does sound like as well things are coming in those other countries as well, so everyone should be on a more even playing ground in the near future.
Yeah, right. Yeah, China is developing their data privacy sort of regime and how that's going to work, and hopefully over time that'll get stronger and stronger.
Perfect. Thank you very much, Lori. That was really useful, and we'll carry on now in our networking sessions. If anyone has any more specific questions for Lori.